Lordship, may I mention item number 20 or 21, Lordship?
Item 20 and
20. Yes, 20 and 21, Lordship. This matter may be taken after 2nd of August, Lordship. Any date, Lordship.
IA is for what?
I am the appellant.
Okay, you are for the appeal.
I want to get it fixed that on 13th August.
30?
13 August.
IA is for what?
My lord,
IA is filed by.
that is for suspension of the interim judgment.
Okay. 1 3.
1
12 13. 12 is program. 30. Hmm? Hmm. Okay. No, so 12 is program. So 30. Can it be 14 is Thursday. So 15 is again. Why not after that?
Well, this is a whole case. The convict is languishing in the jail since last 2 years.
Oh, okay, that is fine. But what I'm saying is 12 is the Silver Jubilee, 13 immediately after Silver Jubilee. Is it okay? Will it be?
In that case, I have to check the date. August. कौन सा डेट है जो है कि मंडे है ना
Monday, Tuesday. This IA also IA has also been filed by you.
Yes, ma'am.
Okay. Okay, Mr. Esquire, Land Counsel for the appellant, and Mr. Loy, Land PP are present, and praise for listing this matter on.
If it is not possible to have matter on 13th.
It can be, but what I'm saying is, if you are really serious about hearing, because this is for hearing, so will it be on 13th? Can it be?
Then we can have it on
a separate day.
Separate, that means then we have to come.
Say 19, 18, 19, anything.
19th, I will be out of station.
Okay, 18.
No. On 18th, I will be out of station. I will be going to Delhi then. I will be there for.
Okay, then when next? Okay. 12 also, no problem. 13 also we can take.
Little early, man. Can it be?
Okay, 13.
Okay, 13.
The prayer is allowed. List this matter on 13 accordingly. Okay.
All right.
Lordship, I beg to mention item number 1. That is for there is at the cost cycle some typographical mistake of section provision. In the item number 1, my lord. So in the cost title, some typographical mistake is just instead of 439 BNSS, it is written 528.
You want to correct it?
Yes, I want to correct it.
Okay.
I want to correct it, my lord.
Mr. Udekar, Land Counsel for the petitioner, some mistakes. There is a typographical mistake in the course title. Therefore, praise for allowing him to correct the same. Then, in that case, you have to file amended course title. Amended course title.
Yes, amended course title only.
Okay, by filing amended course title, the prayer is allowed. When do you want these matters to be listed?
Tomorrow.
Okay. Okay. Let's pray for. Come on, list this matter. Tomorrow team. Okay.
Yeah, please, Your Lordship. I beg to mention item number 22. I'm appearing on behalf of R. Soikia, Your Lordship.
22.
Yes, I'm seeking an adjournment for today.
You're for the petitioner.
Yes, Your Lordship.
Who is for the respondent?
Could you respond, Your Lordship?
There is a private respondent also.
Yes, Your Lordship.
Have you informed? Have you informed the private respondent?
No, Your Lordship, I couldn't find him today. No, Your Lordship, I couldn't find him today.
You could not inform.
Yes, Your Lordship, I don't have his contact.
Are they present?
No,
Item 22.
no, Your Lordship.
They are not present in the court today.
Yes.
Let us see if they are present. In their presence, we'll adjourn it. We'll adjourn it, but wait for some time. Okay.
Okay, in Your Lordship, another item number 4, Your
Since
Lordship.
we have no info. Item?
Number 4, Your Lordship. I'm for the respondent here, Your Lordship.
In item 4, you are for a petitioner. What do you want?
That's adjournment, Your Lordship. I'm referring on behalf of Elbam. He's out of station for some medical emergency, Your Lordship.
You have no objection. You are Mr.
M. Tasso, Your Lordship.
M. Tasso, Land Council appearing on behalf of Mr. L. Baum. Land Council for the respondent number
1, Your Lordship.
1. Praise for adjournment of the matter. Why you seek adjournment? What is the ground for adjournment?
Your Lordship, leading counsel Elbam, he's out of station for some medical emergencies.
L. Baum.
Yes, Your Lordship.
Okay, Mr. So-and-so submits that the leading counsel, Mr. L. Baum, is out of station. Therefore, praise for adjournment of the matter for how much time?
2 weeks, Your Lordship.
2 weeks. To which Mr.
Yes, Your Lordship.
S. Iran. Land Council for the petitioner has no objection. We are allowed. List is matter. After 3 weeks. Stop. The interim order passed earlier shall continue till the next day of listing. Okay.
Oh, Your Lordship, I'm mentioning item number 8. As of now, the pleadings are completed. The matter may be listed in the admission column.
Okay. You are for
I'm for the respondents.
respondent. Who is for the petitioner?
Yes.
You are for the petitioner.
Yes.
Okay. Mr.
M. Tasso, appearing on behalf of
Land
RC.
Council.
There is an
Appearing on
interim, Your
behalf of
Lordship.
Mr. El Noche.
Yes, Lordship.
Land Council for the petitioner.
Here is the interim, Your Lordship.
Your Lordship, P. Ronia for the respondent.
P.
Ronia.
Rania, Land Council for the respondent. Stava. It is submitted. The pleadings are completed. Pleadings are completed.
Yes.
There is the
As
interim,
of-
Your
Has
Lordship.
been
as of-
exchanged. According to brief for listing this matter for admission. Okay.
There is
List
interim,
this
Your
matter
Lordship.
for admission after 3 weeks.
Interim, there is interim.
The interim order pass earlier shall continue till the next day of listing. Okay.
Obligation.
Obligation.
Lordship, I beg to mention item number 23,
23.
on behalf of M. Kato for all the respondent project. Lordship, we have taken consent from the petitioner.
Miss
Yasmin Gao.
Asmiga, Planet Council appearing on behalf of Mr. M. Kato, Planet DSTI, with the consent of the Land Council for the appellant. Praise for listing this matter after
3 weeks, Lordship.
3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Obliged, Lordship.
Your Lordship. Lordship, I beg to mention item number 17. Lordship, in this matter, we have supposed to file additional affidavit. However, still we have not filed yet. Some time may be given.
No, this has been listed for referring the matter before the special mediation drive.
Yes, dear Lordship.
So in that case, if the parties agreed for for referring the matter before the mediation, no need to file affidavit also. Wait for some time, okay?
If you oblige, Your Lordship.
Yeah, my lord. My lord, I beg to mention item number 5. My lord, I'm appearing on behalf of Mr. Omode. He is out of station.
That's okay. No,
I'm for the petition, Your Honor. No objection.
you are Mr.
Dimiu.
Planning Council submits that Mr. and the conducting council, Mr. O Modi, is out of station, therefore pray for adjournment of the matter for 3 weeks, to which Mr.
H time.
H. H.
Time.
Planning Council, so the applicant has no objection. So only the prayer is allowed, list this matter after 3 weeks. Okay. Yes.
My lord, the facts leading to filing of the civil division is, my lord, there was a Kewang decision between the party by the, my lord, customary court. In the meantime, I'm, as a, my lord, the degree holder, file a education petition before the ADC Koduka, my lord, for execution of the decision of the customary court. My lord will file the decision in the page number 20. My lord, may kindly come to page number 20.
Yes, 20.
My lord.
This was earlier. Okay, this was earlier. Yes, adjournment. Page 20.
20, my lord. This is the Keba decision whereby the decision has been taken and directed the respondent to deposit the sum of 10 lakhs, my lord, if he failed to any term and condition. So accordingly, my lord, this is the contention, and my lord may kindly.
It's between the wife and husband.
My lord. Yes.
So husband was directed by this Keba decision.
My lord, the contention of this Keba
Case
decision.
settlement or Keba decision?
This is the, my lord,
Hmm?
Keba decision. In
Keba.
fact, they have written as a case settlement. Decision or settlement, my lord. This is the decision, my lord. But despite that, they have, my lord, written settlement. Whatsoever, my lord, the decision has been taken. And I will take the lordship to the page number 23. Out of the execution, this execution petition was registered as execution petition number 1, and the notice was issued. This is the notice. And my lord, kindly come to page number 24. This is the proceeding of the hearing. Here, my lord, second paragraph, 24, my lord. This order, therefore this order is directing to reply the respondent why the Keba decision dated 8/9/19 should not be executed. The reply of this court must be done within the month and the receipt order, and this order may be challenged in this authority. And my lord, may next, thereafter, my lord, no proceeding was conducted. Dear my lord, in page number 25, the petitioner again approached the authority for conducting of the my lord execution in page number 25, my lord. Now, in response to this prayer, my lord will find in page number 26. 26. Here, my lord, after hearing both the parties, the specific order was passed by the Additional Deputy Commissioner Kodoka. My lord may come to page number 26. Now, my lord, despite of reading everything, my lord, the operation person is second last para, my lord. Is my lord in page number 26?
Yes.
Now, therefore, on receipt of the reply and order or any other respondent regarding the case being the competent authority under the amendment of the AP Civil Code Act 2021 dated 14/11/2022, Shri Kumji Gamlu, judgment debtor is hereby directed to deposit the sum of Rs 10 lakhs as decreed by the Keba dated such and such within 40 days from the date of the issuance of this order in the account of Srimati Yaro Kampung or in the office to the undersigned. Failure to comply this order shall be invite harsh and the legal punishment under the appropriate law. My lord, what they refer the 14/11/2022 is the Arunachal Pradesh Civil Code, Second Amendment Act. Here, my lord, everything was decided and therefore direction was met. But despite that, the respondent has failed to comply this order. Now, the subsequent proceeding is that after filing this, or after passing this particular order, my lord, the authority has stopped or denied to do taken any further action. My lord. So this is not enough to, my lord, compel the respondent to comply this order. My lord. And my lord may kindly come to page number 27.
Can the court give such direction?
Yes, my lord.
Can a court give such direction?
Yes, my lord, because my lord, this has been intentionally, my lord, unattended by the authority.
Any adverse order that it will not proceed? Any orders, such order passed?
The last order is on page 27, my lord.
Okay.
Whereas it has been reported to by the other party that the judgment that was is just and such and comply with the direction of such and such to pay the amount and finalize the Kebang that is such and such and not has appeal against it. Whereas non-compliance of the order repelling against it and view of the willful discharge and intentional neglect to the direction to the authority to do call for legal action. Now, therefore, series such and such judgment debtor is hereby directed to appear before me on such that for final submission and the pronouncement of the punishment as per law. On failure to appear on the scheduled date, warrant shall be issued.
Whether warrant was issued?
My lord. Therefore, my lord, what is to be done against the respondent is to, my lord, issue the warrant against the respondent, my lord. But thereafter, my lord, this is the order of 28 March 2025, my lord. Thereafter, my lord, no action has been taken.
No,
And is
thereafter,
the,
whether you have made any?
yes, my lord. Now, my lord, may come to the page number 28. So, my lord, been made that I may be, since, my lord, this execution proceeding is done under the, my lord, in the spirit of the CPC, I am praying that the order 21 and rule 39 of the CPC may be complied, so that, my lord, I can deposit the subsistent allowance before the court, so that the court executing authority, that is the, my lord, additional deputy commissioner, should issue the warrant of arrest to the judgment debtor, my lord.
Where in the Keba decision that the husband is, should pay 10 lakhs?
My lord.
Where in the Keba decision? Because this order says that husband, directing the husband to pay.
My lord. For that, my lord, we have to go back to the again page number 20, my lord. If we go back to page number 20, my lord will find in the serial number 1 medical treatment. Here, my lord, specifically in the sub-clause B, if Kumji failed to execute the medical treatment within the 3 months and he acts reluctant on his medical treatment, then he will impose that 10 lakhs to pay the area compound as well as
Thereafter,
free from the custody of
whether thereafter, according to you, this Kumji failed to
exactly, my lord.
execute the medical treatment.
Whatsoever in the decision has been completely failed to comply by that.
So according to you, the respondent failed to give medical treatment for the petitioner.
Medical treatment and whatsoever, my lord, all the term and condition, even the single term condition has been fulfilled by the respondent, my lord.
No, this is 3 months given.
My lord.
So according to you, the respondent failed to give medical treatment within 3 months.
Medical treatment and the other, my lord.
Okay, but thereafter, having found him that he has not complied with the order, whether you have filed a subsequent application stating that he has not complied and passed necessary order. Have you filed subsequent application thereafter?
No, my lord. Thereafter, my lord, I have, my lord, continuously approaching after him, but he is avoiding me. Therefore, my lord.
Now, unless the Keba pursuant to this order, first Keba order, pass subsequent order, that since the respondent has failed to give medical treatment, the respondent is directed to, respondent is imposed fine and directed to deposit or give, whether any such order was passed by the Keba
No, my
subsequently.
no subsequent Keba order.
Then,
This is the final decision, my lord. Therefore, my lord, in
so
view,
if see the medical treatment, then he will impose rupees.
so
He
It-
will have to be imposed again now, as per this order, it appears.
for exactly, my lord.
See.
For that, my lord, when I approach back to the authority, my lord, this authority has denied, my lord, that the decision has already
No,
taken.
that is why I'm saying, because he, according to you, he failed. So thereafter, have you approached the Keba to pass some subsequent order in terms of this order?
My lord.
Because in terms of this order, if he failed within 3 months, he will be imposed. So saying that the respondent has failed, now he is directed to deposit or directed to pay, whether such order was passed.
Yes, my lord.
When?
Oh, no. I approach, my lord. My yes is up to that. I
No,
approach back
subsequent
to
order,
the concerned
subsequent
authority.
order, I think
But the
is necessary
subsequent-
to pass.
My lord, I admit subsequent order has not passed.
So then,
On the ground
unless,
that,
unless that is passed, how it can go for execution?
on the ground that, my lord, the decision has already been taken. Therefore, I was advised to go for execution, my lord. So after hearing both the parties, whether that was, my lord, that question was already decided in the execution, that whether this is executable or not, whether that decision is on
Whether
the.
in the execution petition, the respondent has contested.
Yes, respondent has contested.
Okay.
They reply and the executing court has confirmed, yes, now you have to pay this amount. That. My lord will find in the page number 26, ma'am. Opportunity has been given to contest and accordingly reply was also filed. And after hearing of this, the result is in page number 26, ma'am.
Who are the, have you made party to the state here?
Party is, my
The
lord.
state is, the state also?
No, ma'am. Party is only the,
Okay.
this.
Ask Mr. Modi, Hasi Modi, Land Council for the petition. Para. Being aggrieved by inaction of the executing court, the petitioner filed this petition under section, under article 227 of the Constitution of India, read with section 115 of. What is it? 115? You may have to come prepared probably. 115 of the Civil Procedure Code 1908 for issuance of, the praying for issuance of, and so seeking, huh? Where is your prayer? Let us see.
My lord, my prayer is limited, my lord, in the page number.
Seeking direction to the executing court. That is the additional deputy commissioner for Duka from Dapur region to dispose of the representation. Dispose of your representation.
My lord, if my lord this representation is disposed of, my lord, everything will. Purpose will sharp, my lord. If Direction is made to dispose of the representation, my lord.
To dispose of the representation dated 9/5/2025. Submitted by the petition. And to complete the execution proceeding in execution case number 1/2024. No, so this can be disposed of here in the at the motion stage also,
My
with the
lord.
direction to dispose of,
Yes, my lord.
dispose of and then to,
Because everything, my grievances has been ventilated in the detail in 9/5/2025. This can be, my lord,
because there is
disposed,
no other prayer.
my lord. This can be disposed of with this, my lord, motion stage.
Okay. No need to issue notice. Can be disposed of. So in that line, dispose of with the, just note, this with, the petitioner has a limited prayer at this stage, that since he has submitted a representation before the executing court, that is the additional deputy commissioner, Koduka Daporija. The authority may be directed to dispose of the said representation and also to proceed with the execution proceeding in execution case number 1/2024. Start NP of the above. And as prayed for, this petition is disposed of. No, this revision petition is disposed of as a motion stage with the direction to the additional deputy commissioner Koduka Daporija to dispose of the representation submitted by the petitioner on 9/5/2025 with by passing a region order, and also to proceed with the execution proceeding in execution case number 1/2024. So with the above direction, this revision petition stands disposed of. Okay, I'll
My
correct
lord,
it.
my lord, one line time maybe, my lord, frame is specific.
So no, the execution, okay, dispose of the writ petition within a period of 3 weeks from the date of receipt of this order. Okay.
Oh,
May I please?
Yes.
My lord, this is a criminal petition, my lord, under section 528, my lord, corresponding to 482 CRPC, my lord, seeking quashing of the FIR and the criminal proceeding initiated thereby, especially against the petitioner, my lord. Basically, my lord, two grounds, my lord. First is, my lord, in respect of the matter, same cause of action, identical allegation on which the present criminal proceeding is sought to be initiated against me by the police, my lord. That is already the part of the case which is pending trial before the special judge UPR. And this honorable court has also even passed the interim order suspending the framing of charge against me, my lord. My lord, in that regard, my lord, earlier, the petitioner being approached by the registration of the second FIR, my lord, had approached this honorable court, and this honorable court was pleased to quash the second FIR on the ground the identical allegation was already the part of the first FIR. Therefore, my lord, it is legally impermissible to register the second FIR, and therefore direction passed to amalgamate both the FIR. Pursuant thereto, my lord, the first FIR was
What was the allegation in the first FIR?
first FIR that when I was working as a administrator of the Apex Bank Cooperative Apex Bank at Naharlagan, my lord, the allegation is that during my tenure, my lord, more than 71 crores of rupees had been sanctioned without following the codal formalities, all those allegations. So
that case was registered.
charge sheet filed,
right?
even charge frame, but I have put challenge to that framing of charge against me, and this honorable court has stayed further proceeding. As of now, the matter is pending before this honorable court. I have brought on record those.
Okay.
Now-
What is the allegation in the second FIR?
Second FIR, what is done in it? FIR was basically directly not lodged against me as in the present case also. That FIR was against some one person, Thanga Bange. So allegation was there that 5 crore was sanctioned and that was misused. And again, that 5 crore is the part of the 71 crore. The 71 crore is the entire transaction, my lord, during my tenure. Then that 5 crore was also sanctioned during my tenure. So sanctioning of this 5 crore will also come under 71 crore.
Whether the FIR, the accused in the FIR, in the second FIR, one other than you,
Another-
whether he is also accused in the first FIR?
First FIR, my lord, he is also accused first FIR that I have to see, my lord, in the charge. I think police.
Then in that case, he is also accused, probably.
Uh,
The other one,
In the first case, my lord.
in the second case.
In second case, my lord.
Yes.
Yes, my lord.
Well,
Well,
then the amount alleged in the first FIR includes this 5 lakhs, 5
it
crore.
could be because 71 crore.
But this person is involved in this 5 crore only, not in those.
71. He ought to have been made as a accused in
Accused.
that case also. But
Okay.
this is the fault on the part of the investigation agency, which I don't have any control over there, man. Look, I am basically, man, that because
Now see, now it is under investigation, or what is the status in the second FIR?
second affair caused by this honorable court.
No, this present one.
This is
This is against the second.
no, my lord. The second was quashed, my lord.
Yes, and then this is,
Then this is the third FIR.
okay.
Now
Yes.
has been lodged against, not against me again. It is against.
So, but this third FIR is under investigation now.
Yes.
So you are seeking quashing of the FIR itself.
Not for other person.
Okay.
Because
In
only
respect
the
of you-
case
in
is
respect
that
of you.
this cannot be initiated against me because of 2 reasons. First, the same, this is the case where it is alleged that 19 crore, my lord, I will come to that, some 11 phase. 19 crore was allegedly sanctioned during my tenure without following the menu. Now, this 19 crore is also the part of the 71 crore, first point. Now, thereafter, about this 19 crore, already mutually the matter has been settled through Log Adalat, bank and the parties, the person who obtained the loan, my lord. Then by Log Adalat, award has been issued, my lord, directing them to pay some after mutual settlement, 10 crore or 6 crore something, and by installment. And when the accused in the present case, my lord, not me, my lord, when he failed to pay, then a money execution petition was filed. Then that person, aggrieved person, put to challenge that money execution. And again, this honorable court has stayed the money execution. And this honorable court has directed him to pay certain amount and he has been paid. So basically, that is also settled matter. Now, I will show the contents of the third FIR now, my lord. The third FIR is basically nothing. It's something like this, my lord. Basically, for some political motive, what happened? Because one of the accused person in the third FIR, Hayang Mangfi, basically the FIR is lodged against him and one branch manager, Yura Tagu. What happened during the last election in 2019? During the last election 2019, my lord knows that to contest an election, one has to produce the no due certificate. So in the FIR, it is alleged that Yura Tugung, who was the branch manager, he had purportedly issued this no due certificate. So, and enable this Hayang Mangfi to get elected in the 2019 election. Thereafter, in this 2024 election, my lord, again, this issue again raised. Just before election in January, this FIR was filed. Basically, the motive was to get him disqualified during the scrutiny, my lord. So basically, in the third FIR, my lord will not find even a single statement against me, not even any ingredient material against me.
And then you don't have to worry.
No, now
Yes.
the problem, police has called me. I went there, I fully cooperated. Now, police has wrote an application to the secretary because I am a government employee working from the Arunachal Pradesh Civil Service cadre, my lord. Now, seeking the criminal prosecution to proceed against me, to file charge sheet against me, my lord.
Now, in the earlier case, there is the prosecution sanction also against.
First case. First case, yes, my lord. That is there. That is has been now my state, my lord. Now, may I come to now the documents, my lord? just show the impugn FIR, my lord. My lord will find at annexure page number 40 it starts, my lord. No, my lord, no, sorry, my lord. First, impugn, my lord, will find at page number 31, my lord. Starts from page number 31. I'll just read, my lord, kindly page 33.
Yes, this is third, this is.
This is the third paper which is under challenge, my lord, not for quashing the entire FIR, my lord. Only my case is, my lord, that this no case should be registered.
Now, just tell me one thing, whether the police has already examined, this was filed way back in 8 January 2024, whether, have you been examined by the police?
In this case?
Yes.
Yes,
Yeah,
when
what
I was
case is
summoned,
this?
I went there, I fully disclosed that this 71 crore already. And so far in
This
this
cover
case,
under-
cover under, and my lord, this will not come under now misappropriation. Even, my lord, what happened? It is on the record that when I was administrator, the sanction was granted on the basis of the mortgage lane, my lord. And this mortgage lane was sought to be, my lord, sold, my lord. Now this matter is settled, my lord. My lord, my point is that about this loan amount, my lord, by Lok Adalat, my lord, the matter is settled. Now even
So this, in the decision or the settlement before the Lok Adalat covers these 5
this,
crores.
not 5 crore.
No.
Only for this one, this particular FIR, my lord.
Okay.
May I read, my lord? Not for 5 crore. I'll just read, my lord. Complaint against Sri Yura Tagung, then bank manager Itanagar Apex so-and-so, and Sri Hayang Manfi, the Honorable MLS so-and-so is coming for issue of false certificate and act of criminal conduct. My lord, basically this FIR is for issue of this no due certificate, my lord. I'll just read it. It is to inform and intimate your good office that in the sum, well, this very lengthy FIR, my lord.
Okay, anyway, but just let us. Now, the case is still under investigation.
This one, my lord.
In respect of you, in the first FIR,
My lord.
according to you, this covers under those 70 crore.
71 crore, my lord.
71 crore.
Yes, yes.
So
Because
you have
of-
given your own statement.
On that
The-
basis, only the second FIR was cost.
Hmm.
Because that was for the 5 crore.
Yes.
This is for the 19 crore.
Hmm.
And
But here the allegation is against the other co-accused person.
yes, not against me.
Not against you.
Not at all.
Yes, not against you. But during the course of investigation, the police probably might have found something that this person is also need to be implicated here in this case. Therefore, probably they must have approached or for the prosecution sanction.
Oh, that's why, my
Granting
lord.
prosecution
It
sanction.
is not permissible. That is which is not permissible under the law.
Hmm.
First, to police, my lord, first.
Now before granting prosecution sanction also, the government also used to examine.
Let it be.
They will examine whether they, because you will be filing, you have already filed your representation. Have you filed?
No, representation, my lord, not necessary. This
You have
entire
filed your statement.
initiation of
Entire matter will be sent to the.
criminal case, my lord, first, how the criminal case be initiated against them. During the investigation,
Now it appears that
First-
it appears that these should also be clubbed along with the first FIR.
my
Because
submission,
Amount also.
my submission would be, first, my lord, first part, whether this FIR disclose any offense against me, cognizable offense, first thing. Because, my lord, to set any criminal machinery in motion, the first requirement is that FIR should disclose the cognizable offense. Police cannot say during the investigation I have found. First, at least FIR should disclose a cognizable offense. So far, there is no cognizable offense. This entire FIR is basically for issuance of no due certificate by one Mr. Yura Tagung. Basically, that is the contents of the FIR. Second is against Hayang Manfi is that you have not repaid the installment as directed by the Lok Adalat. Entire contents, if Your Honor allows me to read, if I read, Your Honor will find that's only. Nowhere that when I was in, before 2016, when I was.
Just a minute. Why he has been implicated again and again? Because in second FIR it was first.
Therefore, my lord, as far as my,
Because if this amount covers in that 71 crore,
that I'm,
then he cannot be the accused in this case also, because he's already accused in that case.
Therefore, there is a little bit of, dispute, my lord here. Because for that, I need to take instruction, my lord. That's because, my lord, rightly said, my lord, two affairs were already filed, my lord.
Yes.
One that was
One person.
amalgamated and the second affair was passed.
Hmm.
But that amount pertains to 71 crores and another 7 crores. Now, second was filed. This was 17.
19.
But this is, I think, 19 crores.
Hmm.
And this, whether this 19 crores includes 71 or not, that I'm not aware of as of now, my lord, because the FI does not reflect, my lord. So it will be only found when the,
You obtain instruction.
yes, my lord, case record is
Probably
here.
if it covers, then you say
No.
this need to go.
My lord,
This
question
other-
of, my lord, may I submit like?
Yes.
It is not the question of the police saying that in the first affair I have not covered. That's why for every ground of section, I will make separately case this police can do. When this honorable court has already even observed that when 71 crore, the entire granting of loan section is already the part and subject matter of the first FIR, right? So subsequently, there may come 71,000 for separate individual, there may come in lots of cases. Does it mean for 71 crore, I will be prosecuted another? And for again,
No.
on piecemeal
That is,
basis.
that is not,
That
so.
71 crores will be
see,
different.
if it covers, and if it comes under 71,
My lord.
then you see, you cannot just separate it
Yes.
and
Yes,
file
my-
separate FIR
my
for
lord.
all the separate incident.
My lord.
Because if it covers, then duty of the FIR, duty of the investigation agency is to cover entire thing.
Exactly.
And on whosoever is accused involved in, even for the small amount also, since the FIR is for the 71 crore, then everyone should be made accused. And
Right.
if they have made accused and they have failed to implicate somebody, then it's not his fault. That he should be again at least, along with someone has not made an accuse here. And then again, in that connection, this person is also was there, but then since his case is already covered in 71, so he cannot be made an.
That
made
is
an
disputed,
accused
but that is,
So that
that
is
is
the-
which I am disputing, my lord. For that, my lord, at least let me take instruction, my lord.
Okay.
Whether this amount
and-
covers,
Uh,
it comes under the 71 crores or not.
Now, my lord, second submission. First to my lord, already second FIR similar, that has been passed, my lord. Now, second submission. In this FIR, what is the allegation against me? Is saying that without securing mortgage as security, I granted. This is not the FIR alleged that I misappropriated the amount. When I was an administrator, the allegation is only that loan was without mortgage security. But this is a false statement. Why, my lord? My lord will see this loan amount has been settled. When this loanee had failed to pay, my lord, then matter money suit was filed by the bank. Then matter was referred to the Lok Adalat. Award has been passed. And execution proceeding, my lord, this honorable court has already directed to pay him the amount. Now almost this amount is to be paid, my lord. The matter is pending before this honorable. Now another question. Where is the question of, my lord, even leaving aside this first ground, my lord, this second FIR is not permissible. Now let's assume even, my lord, this is permissible. Now, whether this disclose a cognizable offense against me, my lord, when the amount has been settled, mortgage land is there, my lord, is it, my lord, that administrator, what is the function of the administrator? Basically, it is to grant the loan, my lord. But this money already settled by the bank. Now the loanee is paying back the money.
Anyway, the fact of the case would be available with them. So let him obtain instruction.
My lord, that's why, my lord, I am not saying, my lord, today itself to get it cost, my lord. That, my lord, considering all this case, my lord, facts, circumstances, materials on record, my lord. Those materials are there already, my lord. Now, only at this stage, my lord, that an interim order may be, my lord, passed, my lord, that no coercive action should be initiated against me. No further criminal proceeding till the next returnable date, my lord, should be initiated against me.
Proceeding may not be able, but then
Now here, my lord, I think if I'm not wrong, my lord, already we have asked for the prosecution sanction, my lord. The investigation might be almost completed, my lord. So we have asked for the prosecution sanction from the competent authority, my lord.
Now, my lord, now what they want to do is the filing charge sheet, my lord. That's why I have to approach this
No.
honorable court.
Let the government.
Then no further proceeding, my lord, should be initiated till returnable bail. This is a fit case, my lord, more than sufficient prima facie, my lord, on two counts, my lord. First, second FIR, second, my lord, itself doesn't disclose any case, my lord. To anybody, my lord. Now money is settled, my lord. Now paying, my lord. Money execution petition is pending. Now where is the question of misappropriation, my lord? I think this entire affair, even not to me, even to this other, maybe for bank manager for issuing no due certificate false, that I have nothing to, that is none of my part, madam.
Mr. Arsana. Land Council for Petitioner.
Extra, okay.
The petitioner filed this. Petition under section 528 of BNSS 2023, seeking quashing of the FIR number 13. FIR dated
8/3/24. 8/3/24.
8.
8/3/24.
FIR dated 8/3/2024, registered as SIC. Within bracket V is VIZ, bracket plus police case number 13/2024. Under section 120, within bracket capital V, stroke 409, stroke 420 of the Indian Penal Code. Read with section 13, within bracket 1, within bracket small a, and 13, within bracket 2 of the Prevention of Corruption Act 1988. In respect of the petitioner, your prayer is in respect of the petitioner.
My only petitioner, because I
In
cannot
respect of-
ask for
in
other
respect
money.
of Petitioner. What is his name? Dr. Oli Tarim.
My interim prayer, page 27, my lord, fine, my lord.
Hmm?
My lord, interim prayer, my lord, page number 27. A and B, my lord. This is the abuse of the process of law, my lord. Article 1421, all those things will come, my lord.
The case with the petitioner is that in 2016, from SIC, within bracket VIZ vigilance, bracket close, case number 09, stroke 2016 was registered against the petitioner, alleging illegal loan disbursement of rupees 71 crore 29 lakhs 01, 045 during his tenure. He was working as
My lord, administrator,
during his tenure as administrator.
till 2016, my lord.
Hmm. The same case has been suggested.
My lord, this order whereby second FIR was my lord, file at page number 62, my lord. Page number 62, it starts, my lord.
Where is the order by which the second FIR was?
My lord, that's fine, my lord. Page number 62, my lord. Start from page number 62, my lord. Relevant portion, my lord. I will read straightly. I will go to, my lord, page 67 on 67, my lord. At the bottom, my lord, page 67. At the bottom, in view of the settled position of law by the Honorable Court, Supreme Court, as well as the written instruction policy so and so, the present petition is allowed, directing that both the FIR be amalgamated into one case followed by the investigation. It is made clear that the second FIR based on the same set of allegations is declared to be invalid, and consequently the registration of the second FIR would not be taken into any further. And this subject matter, my lord, so far issuance of false FIR, false no due certificate is concerned, this can go separately, my lord, against the person who has issued that. But
It is submitted
yes,
during the pendency of the investigation. The second FIR was filed against the accused petitioner. In second FIR, what was the allegation?
my lord, that 5 crore I sanction as an administrator.
Alleging that the petitioner has 5 crore, alleging you have 5 crore was, that was also
During my tenure as an administrator.
a granted loan.
Yes, yes, granted loan.
The petitioner has granted loan or disbursed.
Loan, my administration, my lord, I have to grant the sanction. I granted the sanction. Disbursal will be
It was
done.
that means illegally granted loan. No.
My lord,
What was
no,
the allegation?
my stand is very clear, my lord. After taking the, my lord, advice of the advisory council, my lord, thereafter only I granted the sanction.
Okay.
That is my case. And in this case, my lord, even there is a mortgage lien, my lord. So, my lord, bank is there to do the banking business. If the bank doesn't grant loan, how the bank will run, my lord?
Granted, the allegation is you have granted sanction illegally. Or
That
what?
is the allegation.
Okay, the alleging that. you have
Basically,
granted
in this,
loan
my
to
lord,
rupees
in
5
the second
illegally.
in the second FIR, basically, my lord, that was not against me again, my lord. That was against some
However, the
Hange.
second FIR was, however, this code by an order dated 4/3/2023 passed in criminal petition number 29/2020 as directed for amalgamation of both the FIR and the second FIR filed based on the same set of allegations was declared to be invalid. And not to take into account of the second FIR any further stuff. Okay. And this is the third FIR. No, this is third FIR.
This is the third FIR.
So this third FIR is filed. There is no allegation against you.
My lord, third
My
FIR.
lord, my lord, according to petitioner, it is the third FIR.
Okay, and
But
this is the third
pertaining to
FIR
that 71 crores, my lord.
pertaining. Here the allegation is in the third.
Basically, this FIR is basically, my lord, for issue of no false certificate and for non-payment of the return of the money by the hiring monthly. Now, in the first paragraph says that this loan was issued without securing the mortgage. That is the allegation, but which is not
Third FIR, which
actually fact.
according to the petitioner, covers in the first FIR, which according to the petitioner, the amount alleged in the present FIR covers the allegation made in the first FIR. That is, we have first FIR, that is. That is the allegation of loan disbursement of rupees 71 crore 29 lakhs 01045. Okay. Okay. Mr. Opada, done it. Standing Council SIC. Prays for some time to obtain necessary instruction in this regard and to confirm as to whether the amount alleged in the present FIR covers within the first FIR, within the amount alleged in the first FIR, that is rupees 71 crore 29 lakhs 01045 or not. Please pray for come. List this matter.
I may be protected, my lord. I don't have any issue, my lord.
Please pray for list this matter when?
After 3 weeks, my lord.
After 3 weeks.
Yes, my lord. My lord, investigation is almost complete. When we have asked for the prosecution sanction, my lord.
Okay.
Meaning that the investigation is almost complete, my lord. We just need the certificate.
List this matter after 3 weeks. Start. Then he need to be protected.
The investigation is complete, my lord.
No.
What protection?
But since you have already given your statement, probably you will not be arrested also.
No coercive action.
my lord,
will not be arrested.
yes.
now.
No coercive as well as further, because now if they file charge sheet, this criminal petition will become infractions, my lord. If the matter is there, then my approaching this honorable court. That's why, my lord, I have approached this honorable court, because to cooperate with the police, it's
Now see here, we've seen that if we pass no coercive action, they might misinterpret not to file even.
No,
charge
my
sheet.
lord. No coercive action will not be.
My lord, charge sheet, how the charge sheet can be filed? When there is
No. Supposing during investigation, of course, now if they are seeking prosecution action, then he has been made as a accused.
Probably, my
But
lord.
if he has given clear-cut statement that it covers those and he is nowhere connected, then the police shouldn't have actually during investigation.
Therefore,
They shouldn't have applied for
prosecution sanction.
granting
Might
of
be, my
prosecution
lord.
sanction, because he cannot be accused in the same for the same offense in two cases.
Therefore, my lord, therefore
Okay, anyway, then till then,
Further criminal proceeding may be so far against me.
further, because it is, as you said, that this is against some other person.
Yes, for them, my lord, no stay, my lord.
Hmm.
Let them go proceed as per the law, because they have not approached this honorable court. So far against me. This FIR, my lord, has seen not against me even.
Now you see, now let him obtain instruction. Let him obtain instruction.
Yeah, my
my
lord,
lord,
because
In three weeks.
My lord,
After 3
I
weeks.
have
whatever
no
is
objection,
necessary-
but my
necessary.
purpose of my lord filing this basically, my lord, I cannot be charge sheeted, my lord. I have cooperated, my lord.
No,
Now, if it is
see,
charge
see,
sheeted
if
means,
there-
my
if
lord,
there is a case against you, we do not know what is exactly.
no, my lord,
We do not
I
know.
have brought on
During
record
investigation, what
everything, my
exactly
lord.
they
I
might
have
have
brought
found.
on record everything. First, my lord, FIR, my lord, has seen. Where is the case against me? This entire allegation.
See, it will go automatically. It will go after 3
My
weeks when the
Then,
things
then,
matters.
my lord, second case, my lord, money education already is stayed by this honorable court. Now
Now
asking.
that entire matter requires, you see,
That's why,
clarification.
So in this circumstances, making some person to go for all this process, my lord,
Now-
go to the trial court,
Now you see.
my lord, this is not permissible, my lord. Prima facie.
While obtaining instruction, we also have to instruct that since the person is already covered, he is already accused in another case where
Madam.
charge also framed.
Yes, ma'am.
So if it covers, it goes against them if they take coercive against
No, therefore, my lord, if,
against the present accused.
my lord, if
Because
there is no, my lord,
anything, including obtaining prosecution sanction.
my lord.
So that will amount to obtaining a prosecution sanction by misleading the authority. So you have to clarify this.
Yes, my lord, yes, ma'am.
Okay. So I think no, because now since
Then-
we have already given statements.
My lord, that's why, my lord, since tomorrow what the prosecution will do, I don't know, my lord. That's why I need a protection from this honorable court, my lord, because this is a clear-cut case of abuse of the due process of law, my lord. My lord, if it is not protected, my lord, then my approaching will be, my lord, will become redundant, my lord. That at least, my lord, this so far two other accused persons are concerned, my lord. Let the criminal proceeding be proceeded, my lord. But against me, my lord, it should be stayed, my lord, and no coercive action against should be initiated against.
Till then, no coercive action shall be initiated against the present accused.
Including, my lord, the filing of charge sheet, my lord.
No.
My lord,
Because charge sheet will be filed against those.
My lord, if there is no case, then my lord, how police can file charge sheet again, my lord, this is.
However, it is made clear that the proceeding in respect of the other accused shall continue. Okay.
my lord, extra plea will be given.
Yes, I will. No coercive action.
Just a minute.
Then, my lord, if
After
the-
they issue notice, issue
My lord,
notice,
then it is-
since Mr.
My lord-
appear and accept notice on behalf of the session.
well, then in
No formal notice need. How many?
only one, my lord, informant, my lord,
Okay.
respondent number 2.
Okay,
Cannot for a week for 3 weeks.
no formal notice need.
One.
However, the petitioner shall serve requisite extra copy to the Learned Council appear, Learned Standing Council, SIC, during the course of the day. Staff, the petitioner shall take steps upon the private respondent
2, my lord.
by a registered post week 80 as well as by usual process within 3 days from today. So list this matter after 3 weeks. Okay.
My lord, since my lord has not, only my lord has of course partially protected me, my lord, since entire criminal proceeding has not been issued, my lord. Therefore, my lord, 3 weeks is too late, my lord, because in the meantime,
2 weeks.
Okay,
2
my
weeks.
lord, 2 weeks. Obliged.
deeply obliged, my lord.
Yes.
May I please, my lord? My lord, this matter is listed for the 5th time today. On last 2 occasions, my lord, this matter could not be taken up due to paucity of time. And on last 2 occasions, my lord, the counsel for the victim has refused to appear before my lord.
Counsel for the
victim, my lord. Therefore, on the last occasion, my lord, this honorable court was inclined to appoint an amicus curiae.
okay, it was a private advocate.
Yes, ma'am.
Engaged advocate. He refused to.
On 2 occasions, my lord,
Tangen was appointed as
amicus curiae.
Marcus.
In this case, my lord, I have been under custody since last 146 days. And
The offense is
offense is under 65(1), my lord, punishment for F. 351(3), criminal intimidation, my lord. Section 4 of POCSO and Section 6 of POCSO. My only very limited ground in this case is that the grounds of arrest to furnish to which is required to be furnished to the accused or the relatives has not been complied with as required under Section 47 of the BNS as well as Article 22(1) of the Constitution of India. that entitles me for a bail right away, my lord. And on the first day also, my lord, on the second hearing, my lord was observation that the grounds of arrest has not been furnished. But since the time has been taken by the counsel for the victim, the matter could not be taken up. If my lord may kindly have page number 21, that's the arrest memo. Before that, if I may read the FIR, my lord,
Yes, sir.
page 17,
Please.
170. The relevant type copy would be at page number 20, my lord. 20. To the officer in charge, so and so, my lord, FIR against Sri Ganyo Ligo, son of Sri so and so, regarding rape of minor girl on the way near Tato. With due respect, I have the honor to inform you that, sir, on 28th February 2025, my elder brother's daughter, Miss so and so of Mechuka town, was coming from Alo through Tata Sumo line. When she came to Sumo, she was only passenger. While inquiry about the rest passenger, the driver, Sri Ganyo Ligo, told her that the rest passenger shall be picked up on the way ahead, but he had not picked up any person from the way after left Alo town. He forcefully locked her in the Sumo. On the way, he threatened her to kill and threw away the body on the wayside jungle area. Reaching near Etato, he grabbed her forcefully and sexually assaulted. She is minor and could not tolerate such trauma and born under depression. Therefore, I request you to take kindly immediate action.
She's minor.
My lord.
Okay, so.
Now, my lord, the arrest memo is at page number 21, my lord.
Yes.
Time, serial number 7, my lord. Date and time of arrest, 4/3/2025, my lord. As of today, my lord, if we compute the length of custody, my lord, it is 146 days.
146.
146 days.
So what is the status of the investigation now?
Has been charge sheeted, my lord.
Okay, already charge sheeted
my lord,
on time.
Yes, my lord. TCR has been called for. TCR is before, my lord.
Okay.
Trial court report.
After charge sheet? Okay.
My lord, if my lord may peruse page number 22 for a time being, my lord, the arrest memo. My contention is that the grounds of arrest, which is required to be furnished to the alleged accused person, has not been furnished. That is my only ground. Now, the grounds which they have stated in the arrest memo are the
In
reasons of
Arunachal
arrest.
Pradesh, whether this format
My lord.
have ever been filled up by the police other than ticking mark?
These days, it is being done, my lord.
It is
After
being done.
certain orders.
I've never seen
My lord.
doing that.
After direction from this honorable
Because
court.
they thought that doing that prevent accused person from committing a tick mark.
Yes.
So they thought that this is the one.
Yes.
And thereby verbally informed, but they're not written here.
Yes. Even otherwise, these observations, my lord, prevent accused person from committing any further offense for proper investigation of the offense. These are not the grounds of arrest, my lord. As these are the reasons of arrest, as of in various authorities, my lord, by the Supreme Court as well as the coordinate bench of this honorable court. If my lord allows me, I'll place those authorities. I have made some compilation, my lord, of the judgments. I have made some compilation of the judgments. If my lord allows me, I'll just place it.
Okay.
First judgment, my lord, Pravir Purkayasta, was reported in 2024 8 SCC 254, starting from page para 22, my lord. If I may read para 22, page number 11. First judgment, para 22. The right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate. Para 22, page 11.
Page 7.
Page 11, 111. First judgment.
Page?
Page 11. 11.
11.
Para 22.
Okay.
The right to be informed, madam.
Yes.
The right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that the charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the accused and the grant of initial police custody remand to the accused, my lord. Now, para 30, my lord.
Yes.
Hence, we have no hesitation in reiterating the requirement to communicate the grounds of arrest or the grounds of detention in writing to a person arrested in connection with an offense or a person placed under preventive detention as provided under Article 22(1) and 22(5) of the Constitution of India is sacrosanct and cannot be breached under any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody or the detention being rendered illegal as the case may be. My lord, last observation, my lord, para 49. Para 49.
Yes.
It may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters, which to prevent the accused person from committing any further offense or proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person for making inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts of the court to the court or the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitate the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest which are general in nature. Paragraph 50, my lord. From the detailed analysis made above, there is no hesitation in the mind of the court to reach to a conclusion that the copy of remand application in the purported exercise of communication of the grounds of arrest in writing was not provided to the accused appellant or his counsel before passing of the order of remand dated so and so, which vitiates the arrest and subsequent remand of the appellant. As a result, my lord, the appellant is entitled to a direction for release from the custody by applying the ratio of the judgment rendered by this court in Pankaj Bansal. Accordingly, my lord, the arrest of the appellant followed by the remand order that is so and so, and so also the impugn order passed by the High Court of Delhi that is so and so are hereby declared to be invalid in the eyes of law and are quashed and set aside. Though we have been persuaded to direct the release of the appellant without requiring him to furnish bonds or security, but since the charge sheet has been filed, we feel it appropriate to direct that the appellant shall be released from custody on furnishing bail and bonds to the satisfaction of the trial court, my lord. This was reported in 2024-8 SCC 254, my lord. Now, if my lord may take peruse the second authority one. Vihan Kumar versus State of Haryana. I'll start from para 16 now. Para 16, page 11. May I read? An attempt was made by the learned para 16, 16, page 11.
Yes.
An attempt was made by the learned senior counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody and now a charge sheet has been filed. His submission is that now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting such arguments with great respect to the learned senior counsel will amount to completely nullifying the Article 21 and 22(1) of the Constitution. Once it is held that the arrest is unconstitutional due to violation of Article 22(1), the arrest itself is vitiated. Therefore, continued custody of such person based on the orders of remand is also vitiated. Filing a charge sheet and order of cognizance will not validate an arrest which is per se unconstitutional, being violative of Article 21 and 22(1) of the Constitution of India. We cannot tinker with the most important safeguards provided under Article 22, my lord. Para 21 again, my lord. Therefore, we conclude the requirement of informing a person arrested of grounds of arrest is mandatory requirement under Article 22(1). The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of communication must be such that the object of constitutional safeguard is achieved. When arrested accused alleges non-compliance with the requirement of Article 22(1), the burden will always be on the investigating officer agency to prove the compliance with the requirement of Article 22(1). Non-compliance with Article 22(1) will be a violation of fundamental rights of the accused guaranteed by the said article. Moreover, it will amount to a violation of the right to personal liberty guaranteed under Article 21 of the Constitution. Therefore, non-compliance with the requirement of Article 22(1) vitiates the arrest of the accused. Hence, further order passed by the criminal court of the remand are also vitiated. Needless to add that it will not vitiate the investigation, charge sheet, and trial. But at the same time, filing of charge sheet will not validate a breach of constitutional mandate under Article 22(1). When an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance of Article 22(1) and other mandatory safeguards has been met out. Malak, this is important, man. When a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail, even if statutory restrictions on the grant of bail exist. Like in the present case, my lord, it falls under POCSO. The statutory restriction do not affect the power of the court to grant bail when the violation of Article 21 and 22 of the Constitution is established, my lord. Now, if my lord may take to the third judgment, my lord, in reference to the case of POCSO, the coordinate bench of this honorable court has granted bail, my lord. I'll read para 2 and 15, my lord. First, I'll read para 2.
Ms. L. Hage, then additional people for the state respondent and Ms. Gandhi, for appearing on behalf of the victim. I'll pass over. Okay.
Sorry, Lordship, just
Yeah.
it's my actually just a personal request. In fact, some sort of stricture may be passed against the police.
That's it.
Oblige.
Now it says that nowadays this filling up the police is doing after probably this court has also issued some order earlier.
Yeah.
May I please, Your Lordship?
Yes.
May I please, Your Lordship?
Yes.
This is the bail applications, regular bail applications moved by the wife of the alleged accused Lordship. She's one housewife and she's having two minor children. One of the child is a special child, Lordship. In the last occasions, Your Lordship, twice the court, this honorable court has directed to
Who is the accused?
husband, Your Lordship.
Accused is the husband.
Yes, Lordship.
The offense is under, what is the allegation against the husband?
103, Your Lordship. And last occasion, Your Lordship, this court is directed to some scanned copy of the trial record as well as a scanned copy of the case diary you submitted, Your Lordship.
Lordship, we have
Let us see the FIR. Where is the FIR?
Your Lordship, FIR is in
Okay, it's the date of the child.
Yes.
The father threw the daughter.
Yes, Lordship. Accused his father, Lordship. He killed his own daughter.
Okay.
Lordship, we have already received the instruction that the charge sheet had already been charge sheeted and the record has come, Lordship.
Trial begun.
Lordship, they have lordship production
Trial
of the
begun,
lordship.
not-
Yes, lordship.
Yes,
Yes,
it's
lordship.
already commenced, Your Lordship.
When he was arrested,
This is, this 1/1/2025, Your Lordship.
how long? That means.
Already, Your Lordship, at the time of filing this bail, it's already 180 days, Your Lordship. I just want to take to the Lordship to the FIR also. If you see the FIR copy, Your Lordship, I just want to go through it. I send page 15, Your Lordship. I
Yes.
just want to go through the relevant portions only.
Mm.
Yes, Lordship. This FIR was lodged by police officers of Your Lordship. I just want to go through the FIR. With due respect and humble submissions, I would like to inform that at around 9-10 hours, I have received an information over EBO, that means emergency.
There's a clear case, it appears there is a clear case against the accused.
Yes, lordship.
The witnesses stated, the wife herself stated. Even from the FIR also, it's very clear, isn't it?
Your Lordship, I just want to go through the FIR. It's not, maybe the police officials has mentioned about the throwing, but if you see the statement of the, you go through the statement of the wife also, it suddenly fall from the hand, Lordship. And it's what under the influence
Let
of
us see
the
statement of
alcohol.
the wife. Because as per the FIR, there is a clear case against the accused. Where is the statement of the wife? Wife was there, wife is eyewitness. Wife was eyewitness to the case.
Not exactly.
Wife was present at the moment when the
Yes.
incident took
Yes,
place.
Lord.
Where is the wife? Statement of the wife. Let us just see once. What is the name of the wife? What is the name of the wife?
Wife is Purnima Devi also. Purnima Devi. Poonam Devi.
Who is this? Miss Muni Devi.
Okay, neighbors.
Okay. Yes, anything to submit?
As a Lordship, I just want to go through the FIR, Lordship, page 15, Lordship.
Okay, I've seen.
Yes. where it's the police officers that has clearly stated that on examinations of the deceased mother, she stated that her husband's Ram Vilas Thakur in a drunken state. That is a very relevant. It is one, and thrown her on the ground. And due to the
Do you have anything to submit?
in fact, Your Lordship,
Lordship, in the prima facie, it is reflected here, Lordship, this is purely Lordship, murder case, Lordship. Here, Lordship, wife, which is the mother of the victim, Lordship, she was the eyewitness, and Lordship, here, intention of the accused also revealed in the FIR, Lordship. He ran away, Lordship, and hiding, Lordship, from the arrest. That is, the intention is clearly drawn, Lordship, to attract the section, Lordship, 1003 of the BNS.
See, the
And Lordship, here, Lordship, as the trial already been commenced, Lordship, so Lordship, in the similar Lordship, the judgment, Lordship, which I have produced just beforehand, Lordship, expressed state of Rajasthan, where Lordship, the serious offences like rape, murder, and this one kidnap, Lordship, if trial already began, that if trial may be commenced, Lordship, peacefully commencement done, Lordship. Lordship, here, Lordship, as per the record, the next date is fixed on 24/7, 25 for the production of PWs.
Your
By this stage, Lordship, bail
what
now.
is your ground for?
one is that Lordship, he's the only bread earner, Lordship, in the house, and wife is the housewife, and having a two
What he
minor.
was doing, what he was doing before he died?
Yeah, running a barber. Yes, so
Running a
barber.
okay.
Yes, yeah. I'll just.
He's a barber.
Yeah, not barber. It's running a. I just want to go through it.
Okay.
I'll just go through.
You run a saloon.
Yes, yes.
Pardons.
Yes.
Another counsel for the petition. Also heard Miss Elhage.
Yes, Lordship.
Then additional PP.
Para 3, Lordship.
For
So
the state
barber.
staff.
Lordship, such kind of incident cases is comes under rarest cases where the father himself killed his own daughter on the stage of drunken.
I don't know, but then well noted started.
Yes, Lordship, the FIR is there, yes,
You must
Lordship.
have seen the statement of the wife
Yes, Lordship.
and also the statement of the women with whom this accused person had some argument.
Lordship, here, Lordship, the eyewitness is Lordship, the accused wife, Lordship, who has lost the complaint.
Have you seen? Have you seen?
Yes, Lordship, here, Lordship, FIR, Lordship.
FIR is not
yes.
by the wife.
Lordship, that is, Lordship, FIR, Lordship, is Lordship by the police officer, but is narrated by the wife, Lordship.
See, but you see the statement of the wife.
That's why, Lordship, their statement should be recorded first before the trial court also, Lordship, because PW just started, they have calling for the PW for the recording of the statements.
See, the statement in the FIR by the police stated to be narrated by wife is quite different.
Yes, Lordship.
From
That's
the
where I was
police
pointing out this
police
one.
statement.
That's why, Lordship, there is every chances, Lordship, because tampering, Lordship, can be possible, such kind of tampering.
There's no chance. This small. Yeah.
That's why, Lordship,
And then she is facing trouble, it appears. Where have you said? Is the petitioner his wife?
yes, Lordship.
The petitioner, who is wife of the accused, has filed this bail application under section 483 of BNSS 2023. Praying for granting bail to the accused. Ram Vilas Thakur, who was arrested in connection, who has been arrested in connection with New Jersey PS case number 01/2021 under section 103 of BNS Act 2023. The case of the petitioner is that on the information received over phone, one SI Niri Rama SI Niri Rama of police station Naharlaguna filed an FIR before the OCPS New Jersey, alleging that the mother of alleging that the accused, the mother of the deceased stated that the accused, who is the husband and the father of the deceased, the husband and the father accused, who is the father of the deceased, in drunken state had thrown our daughter, deceased daughter, on the ground, and due to the impact of the throw, the deceased laid lifeless on the ground. This is succumbed to is her injury. Accordingly, the case was registered being usually PS case number 01/25 under section 103 BNS. After BNS and arrested the accused. On 1/1/2025. After completion of investigation, the IO has submitted the case into charge sheet against the accused. Already submitted into charge sheet.
Yes, already.
For offense under section 10, same section
103.
103 BNS. I'll complete the dictation. Okay, dispose of. I remove. Okay. We complete the other matter. I'll
Obliges.
and dispose of. Dispose of. We'll dictate it immediately. This is item. Yes. Now, no one cares on behalf of the parties on call. the list matter after 3 weeks. Okay. The parties are present. Yes. On the loss of occasion loss of TC was called for TC is there. So this method may be fixed for admission here in Lordship. Okay. Mr.
E-Pine.
Non-counsel for the petitioner. Also, Mr. Lloyd. PP. The file for the court has been received. Any other private parties?
No, no, Lordship.
No private party?
No, Lordship.
Okay. In view of the, since the parties are represented and the record has been received, let this matter be listed for admission after 3 weeks. Okay.
Deeply obliged.
May please, Your Lordship. Your Lordship, so this is a criminal petition challenging the two vital aspects, Your Honor. One is Interim FIR, which is lodged against the petitioner on 29/5, and the another one is the Interim order, passed by the London Trial Court Bill on 30/5/2025. Basically, in this case, Your Honor, it's a civil dispute turned into a criminal proceeding, Your Lordship. There is a very vital fact to be decided in this petition. The petitioner who is behind the bar for last more than 60 days, without no fault of her. May I go to the impugn FIR, Lordship, which is annexes page 61. If Your Lordship kindly go to the FIR, Lordship, it will clarify it's a civil dispute for time consuming, opting to a criminal proceeding, Your Lordship.
There is a private respondent also.
Yes, yes. We have taken steps upon the private respondent, Your Lordships.
Service petition is awaited, Lordship. It is
But
still awaited. It is still awaited, Lordship.
But the thing is that the lady who is a mother of three child, is behind the bar for last more than 60 days of no fault of him. Now the apex court has time and again deprecated the incident which has been in civil nature for camouflage or vexatious
Whatever may be, let them appear first. Let them
No,
appear.
Lordship, but the thing is that I may be pray for bail in this case, Your Lordship. The rest of things that quashing is after the appear of the respondent number 2, I have no issues. But at this moment,
Criminal petition. This is quashing petition.
it's a quashing petition. I have also prayed for an interim bail of the petitioner, which is very much vital. She is lagging behind the bar. Yes, it's an interim. I have also filed for pray for interim interim bail also.
Interim bail.
Lordships, in my prayer, Your Lordship, if Your Lordship kindly go to the prayer also.
Why don't you file a separate bail application? Bail?
Because
No, Lordship. No,
I have
for the operation of this for quashing of FIR, Lordship, and
Quashing of-
stay the FIR, Lordship.
and also in interim protection, I have prayed before a bail also. That is why it is a back-to-back FIR has been lost against me. A person who has been arrested in way back on 24/2025 till now, the second FIR has been lost, and I have been put in behind the bar. The most vital aspect of it is that the arrest memo which has been not in violation of the Article 22(1) and 22, which my earlier friend in the earlier class has already been apprised before this honorable court regarding the police has not complying the provision. That is why I am rightfully granted bail in this case, Your Lordship. If Your Lordship kindly go to the FIR, Your Lordship, very much interesting, Your Lordship. How a civil dispute turned into a criminal proceeding, Your Lordship. May I read the FIR, Your Lordship? Which is page 61. Now, for a agreement, how this lady who is a mother of 3 child has been implicated in this case, Your Lordship. That is the moot questions, and this issue has been already been settled by the Apex Court in number of decisions. And recently on 16/4, the Apex Court has also imposed a cost upon the state for misusing the abuse process of the court. Now, if Your Lordship's kindly FIR and the undertaking, which is the basis for the lodging of the FIR.
Let the respondent, since you have taken and it is taken steps, it is still awaited. Let him appear.
No, Lordship, yes, I appreciate it. I bow down to Your Lordships, but thing is that I have been, without no fault, I have been in jail. That is the biggest issue. Your Lordship, kindly go to the entire aspect of the matter, kindly see the arrest memo also. And the most vital aspect that the lady who has been not been produced before the learned court below within the 24 hours of our arrest, which is a completely violation of Article 22(2), Your Lordship. It will completely negating all the constitutional provision. That is why the Apex Court in an earlier case, Your Lordship, and Bihan Singh also cases, I have
earlier case means
there is an earlier FIR has been lost, and I got the bail, Your Lordship. I got the bail.
Have you annexed that?
Yes, Lordship. I have annexed the bail, which is annexer.
That is in connection with the same matter.
No. There is another FIR, and there is a second FIR.
You are involved in another case also, similar case.
Similar case that has also been civil nature, but I got a bail. That's how I got the bail. I already get.
In that case, you are rent fraud. It will be difficult then.
No. It's an allegation of the fraud which has been done by my father. Now, if I go to the undertaking, which will clarify these things, all these things. Whether my liability is required or not, whether I am being entitled for criminal action or not, this will clarify on the undertaking from the respondent number 2. May I read the undertaking, Your Lordship? Kindly give me a moment. Which is page 65, Your Honor.
Just a minute. This has been already filed. The court also passed some order, Chief Judicial Magistrate.
Yes, without taking into account of the Article 22(2), Your Lordship, not producing me within the 24 hours of my arrest, which is violation of the constitutional provision. And they
already arrested.
Already arrested.
Already arrested in this case.
Yes, also. I am behind the bar, Your Lordship. In the second case, I am behind the bar for more than 60 days.
Not yet released.
Not yet released.
Have you filed bail application?
Your Lordships, earlier one application, bail application we filed in connection with 0 PS case number 8, which subsequently this honorable court granted me bail. But on that very day, when I got the bail on 29, the second FIR has been lost against me without any reasons, without any vexatious allegation against me, which is criminal from the itself of the undertaking, which I annexed in 65. It will clarify everything, Your Lordships. Whether I am entitled for criminal action or not, whether it is a civil dispute or criminal dispute, whether my implication will be reflected.
Just a minute. What is the case?
Lordship.
Lordship, in fact, this matter was endorsed to one of my additional people, Lordship, but he is not turned up. So,
No,
Lordship,
Your Lordship.
this is for quashing of FIR, Lordship. And
It's
in the prayer, he prayed for bail application.
He is mixing up so many things. That is why.
Yes, Lordship.
I could not just make out.
In the prayer, he seek bail, Lordship.
No, Lordship, can you go to the FIR, Lordship? You will clarify 61 and undertaking and the learned court below's order, Your Honor. And my prayer
Page
in
22, Lordship.
Just wait.
Lordship.
We prayed for bail in the page 22, Lordship.
Page 22, prayer.
Yes, yes, Lordship.
So this is pending disposal of the rule, so and so. Well, please to stay the impugn FIR. Why?
And or to allow the petitioner on bond bail in connection with
Passed by the. What is the order of the passed by the Chief Judicial Magistrate? What
Lordship.
order was passed by Chief Judicial
Lordship.
Magistrate?
which is annexer in page 71. It's a type copy. Annexer K.
Page number 71 is for custodial inquiry only, Lordship. Custodial investigation.
They were already inside a custody in connection with some other case.
Yes.
This is only permission for custodial interrogation since they are already inside.
No, there is a sworn arrest has been
This is not a bail order, Lordship.
It's not bail order. It's custodial interrogation. Just a
Yes.
minute.
Lordship, I have challenged this order, Your Lordships, because non-compliance of the Article 22 not produced me before the learned court below after 24 hours of my arrest. My arrest, Your Lordship, kindly see the arrest memo, which is annex page 67.
Just wait.
Lordships.
The eye of the case is allowed for custodial interrogation at judicial lockup. The jail authority shall facilitate for custodial interrogation. So what else?
This is daily order, Lordship. Daily order, Lordship.
Yes.
Not bail order, Lordship. Court daily order.
I think he has something else. I don't know where from he is submitting.
With regard to the Lordship.
Just a minute, let us see his prayer. He is unable to make it clear. Oh, by this you are also praying for bail.
Lordship.
What there is a difficulty in filing bail application? What is the difficulty filing bail application?
Because
for
it's
his
a
release?
Lordship, it's a back-to-back FIR has been lost against me. First of all,
Yes.
it's a back-to-back FIR. Now first bail PT application which has been allowed on 29/5 at evening hours. This impugn FIR has been lost against me. That for quashing up that petitions, I have, since it's a civil dispute, I filed this criminal.
You are wasting time. You are wasting time. Accused is unnecessarily lodged in the jail.
Lordship, since it's a civil
for disposal of this case, we need to call record. We need to hear the parties, and then if you are depending on the bail prayer here in this case, it will take time. What is the harm if you spend some 3-4 pages for filing bail application, separate bail application?
Lordship, there is no harm, Your Lordship. But the thing is, the situation is that Lordship, there's a situation is that
in one application you will file bail application also, quashing petition also, quashing petition also.
I have
What else?
I have got the
What else?
I have got the information that 30 people are waiting for me to lodge
And
FIR.
again, corresponding case, and also not to arrest and detain the petitioner in any subsequent
Lordship.
allegation.
Lordship.
See, you are
Lordship.
praying for the future also.
Because 30%
You have covered the past, present, and future also.
because 30% are waiting for me to lodge FIR, vexatious FIRs against the police station in 0, your lordship. Because the moment I got the bail order, the evening another FIR has been lodged against me. That is my great apprehension that
Mr. Lieutenant Counsel, after committing an offense, you want the protection future for
no, sir. Can I go to the your lordship undertaking for FIR? It will clarify. Can you give me a moment? FIR. Will it disclose?
Let us come to this case.
Lordship, let's say FIR. Let us say FIR.
I think your physical presence would be necessary. You are not clear.
Oh, lordship, not clear. Lordship. It says
You are you are unable to make the court about your case. So that is why face to face would be very would be
necessary.
better.
Lordship, kindly bear in mind page 61.
Mixing up so many.
Lordship, kindly see the page 61 FIR for bear moment, your lordship.
Let us confine to this case.
Lordship, this is a case. This confine this case, your lordship. Page 61. Annexure H.
Yes.
Then
Failed to travel the person after his death and about 1%.
and if I lordship, kindly go to 65, page 65, the promissory note.
Even it is difficult to understand the FIR also. After his death, the above named person took responsibilities.
Lordship,
to pay
page,
me after death also.
page 65. Undertake.
What is FIR? This is FIR.
Yes, that is an undertaking has been made
Yes.
by making an arm twisting by the respondent number 2 and along with other persons. Page 65, you know.
Okay. Since the service upon the respondent number 2 is awaited, they are already under custody. Let us wait for some time.
No,
Let him appear, clarify, and you also appear. Probably, since there is some complications in your prayer also, you may have to come physically. Okay. Okay. Mr. You are Mr.
H. Borua.
H. Borua, Line Counsel for the petition. Also had Mr. Loy. Mr. Loy. The office note dated 29/7/2025 reflect that the service upon the respondent number 2 is still awaited. In view of the above, let this matter be listed after 2 weeks.
No, lordship, 1 week. Can you give 1 week, your lordships? After a week. we are taking,
After 2 weeks.
Dear Lordship, can we fix a date, Your Lordship?
18 August, okay.
Deeply obliged.
Deeply obliged.
Yes,
So this application
I is for what?
is for vacation, my lord, and alteration of the, my lord, this order, interim order dated 21/5/2025 passed by this honorable court, my lord, whereby this impugn judgment of the male body has been suspended. Today, of course, my lord, this IA may not be possible. We will have an argument, but only the problem what happened, my lord, because Kebang decision decided the title in my favor. The land was under my possession. Now, what happened, my lord? The moment the stay, my lord, got from this honorable court, my lord.
Order modification of 21/5.
Yes, my lord.
Your Honor, without killing time of this
No,
honorable
my-
court and my
that's why-
learned
that's
senior
why.
friend.
Now, my lord. That's
Since
why
I have received the IA yesterday.
That's
So
why, my lord.
opportunity.
Today, my lord, for the all this, it will need the argument, my lord. I'm not pressing for the disposal of IA today. What is the problem, my lord? Is that, my lord, the moment the Kebang decision was suspended by this honorable court, my lord, the petitioner randomly, my lord, completely destroyed the forest active areas, my lord. This was under my possession, my lord. And now, therefore, my lord, till during the pendency of hearing, my lord, only that both the parties, my lord, not only me, my lord, both the parties should not maintain status quo and should not carry out any, my lord, activities in the suit land, my lord. Because, my lord, let me complete. You will have your chance. My lord, I approach OC, I approach Deputy Commissioner, but the problem is that they are saying, since the matter is pending before the Honorable High Court, they are not in position to take any step against the petitioner, my lord. So, whether this is maintainable, not, my lord, we will have a discussion on the point. It will not harm anybody, my lord, that both the parties should not carry out any activities, my lord. My lord, now, my lord, if I take the photographs, because kindly turn to page number, my lord, 53, my lord.
53 of the IA.
IA, my lord. After getting the stay, my lord, wrongly interpreting that he has won the case. And thereafter, my lord, this distraction he is doing, my lord. Now, I want, my lord, whatever happened, my lord, both parties should refrain. Otherwise, my lord, that ownership was decided in my favor, my lord. So, my lord, because now, even if I have lost several complaints to the police officer, DC.
See, the president doesn't have the power to decide any case.
My lord.
President of the GB Association.
My lord, that part, my lord, we will have a discussion, my lord. During that petition, at least, my lord, both the parties should not destroy the forest, my lord. And we will argue on that point, my lord, whether this is maintainable or not, my lord. Because on my opinion, my lord, this revision is not maintainable. Because once, rightly or wrongly, impugn mail order has been issued, my lord, there is an appeal provision. This is to invoke appeal provision, my lord. There he can resolve the issue.
Probably the contention is that he doesn't have a power.
Yes. No, here is the case, my lord. He's not the
no
case.
jurisdiction.
No, my lord.
It's a
Decision has been given. Now, once decision is given, that whether has
a decision given by the village authority doesn't have a jurisdiction.
Even then, my lord, even then, how then civil revision will be maintained? Because the matter has been disposed. And against which
maybe the person who doesn't have a power to dispose of the matter, the power to decide.
Then even civil revision, how it will be applicable? Civil revision also, it is against the order passed by the competent authority, civil body. It is the same thing. If it is civil revision, if we say that they are not competent authority to pass the order, then even civil revision will not be applicable. Then if we say that they are the private parties, how then civil revision will be applicable to them? Therefore, those issues I will argue.
220, they have filed under 227.
I will argue on those points, my lord. I will I will try to satisfy, my lord. Maybe, my lord, I'm not concerned, my lord. Maybe tomorrow this honorable court may set quash aside also. Not the issue, my lord. Now, my lord, at this stage, because today I want to argue on the merit.
Well, issue notice.
He is already,
notice.
He's representing, my lord. My lord, my prayer is, my lord, kindly, my lord, appreciate my problem. Here is a decision in my favor. This has been suspended. I am not saying. my
Under
lord,
whose
that
possession all those properties?
it was under my possession, my lord. That's why the decision was in my favor. Now the question, my lord, this is a disputed question of fact. Now assume, my lord. Now, my lord,
No,
he is-
see, if the property is under your under possession,
my lord, definitely it was decided. in
and
my
then
favor.
only the stay of
Yes.
the operation
Yes,
of the GBs.
yes. Now he went and he started destroying. Then I
No,
complained.
because it is under your possession. That will amount.
That's why, that's why I lodged a FIR. I went to the DC also. I went to the village authority also that he is destroying. But what is their contention? That matter, since that judgment has been stayed by this honorable court, they are refraining from taking any action, saying matter is subsidized before the High Court. So today what I am saying, my lord, is both the parties, even let this order be against me, both the parties should not do any activities during the pendency of at least this criminal release. This will not harm anybody, my lord.
No, it will.
Or my lord can observe, this pendency will not have any, will not bar a appropriate authority initiating appropriate action against this encroachment.
No, this court has only stayed the operation of the judgment, and according to you, the land is under your possession.
Yes.
So
now what I can do, my
only the judgment has been stayed.
Yes, my lord.
So
Now-
since the possession is under you,
Yes.
No.
then they cannot disturb.
My lord,
The
actually,
the property is under whose possession?
in my possession, that's why,
That
my
is a
lord,
disputed question of
my
fact.
lord, I was cultivating Zoom land there.
Now, my lord,
During that
my-
time-
what will happen, my lord?
It will be difficult.
During that time,
My
I
lord,
have already
therefore-
planted petty
Therefore,
tree.
my lord, if my lord
Okay,
doesn't
okay.
direct my lord, both the parties to maintain scope, there
That
is
will-
highly chance.
Mr.
My lord.
No, my lord, that will amount
Applicant,
to.
wait. I counsel for the applicant. So, this is an application. File seeking alteration, modification, vacation of the ex parte interim order dated 21/5/2025, passed by this court in civil revision petition number 50 of 2025. Whereby and then staying the operation and effect of the order dated 16/4/2025, 21/4/2025, and 22/4/2025, issued by the circle officer, Parang Circle, Papumpari district. And also the impugned judgment and order dated 27/4/2025, passed by all Parang Circle Gambura Welfare Association, staff. Issue notice, since Mr. Land Council would appeared and accepted notice on behalf of all the respondents.
Yes, my
No,
lord.
I'm two.
There are two.
Two respondents.
Yes.
Both the respondent, okay.
What respond?
For both the respondent number 1 and 2, no formal notice need be issued. Required to be issued, staff. You want to file objection?
Yes, literal objection.
Okay, Mr. So want to file an objection and praise for some time. Stop. So when the civil revision petition is fixed?
No fixed date has
It's
been.
no fixed
Not fixed
date,
date.
yes.
Okay. It's after 3 weeks, no? At least this matter. Along with the CRP number 50 AP 2025 after 3 weeks. Okay.
Now, my lord, both the parties should not maintain status quo and should not undertake any action. But what will be a problem, my lord? Now, administration, they are also not taking any action. Now, what will happen, my lord? There will be a very volatile situation. If any either of the parties allowed to carry out the activity.
No, I'm not carrying any activity now, Your
That's
Honor.
why.
My lord, I'm not carrying out any activity now. Only I have planted.
What is the harm, my lord?
No, you are not clearing. You are not clearing the forest.
No. You know, that time I was cultivating for June cultivation. I cleaned the jungle and I have planted feddies, I planted cucumbers and all. Now it is fruiting. If that is vacated, then I will be allowed to collect those vegetables and all. Therefore, my lord, at this stage,
You
I'll.
file objection.
Yes.
My lord, what is the problem, my lord? Kindly
because
try to try to, my lord, appreciate the problem.
I
Now,
could
what
understand because you submitted that it
My
is
lord,
under your
how
possession,
this
but it is,
affect anybody, my
but
lord?
it appears that it is under their possession and they have been cultivating.
Yes.
these years. Then in that case, it is
Try to understand.
if they have
My lord,
already planted.
Or rightly or wrongly, possession, let's assume it is a disputed question. of fact. Now, this is all the false establishment. At this stage, it is very difficult to understand. Now, if we are only saying no further damage, my lord, then tomorrow I can also
Now,
go and
now
say
you
that-
see, under the circumstances, if we pass such order, because they are cultivating the fruits, they need.
No,
and then
further
if you say-
development
if you
is
say
not,
that
well,
there's
we are not saying that my
plucking
lord
of
will
the
pass.
fruits,
Plucking fruit he can do.
amounts to destroy, then it will be
No,
very
my
difficult.
lord, my lord.
Let us after three
My lord,
days
you
to
see, it is
clarify.
a very
Let them
serious-
file.
My lord,
You
very-
file the latest,
No.
along with
My lord-
along with your objection.
My lord,
file the
kindly,
latest photographs
my lord,
also.
kindly try to appreciate the situation. Now, real fact, I was in the position after that he entered destroying. I went to the officer in charge, DC, everything I been goes here. Now, if they are not interfering because of the matter is pending before this honorable court, then my lord, what is the remedy I have with me? Now, only the remedy I have left is to watch him to do. That's why I am saying, because
There is a
authorities
remedy.
are not.
There is a remedy. If the title is decided in your favor, there is a
Now, in the meantime, he is destroying all the forests, my lord. How it will, my lord,
if the forest is declared,
how this will be, my lord,
then
told
it will be
is a fast.
compensated. It will be assessed and you will be compensated, adequately
my lord,
compensated. They are
forest-
bound to compensate.
My lord, is
There
it
is
mean,
a
my lord,
remedy,
now,
there is a remedy.
now, my lord, in your, my lord, rightly or wrongly, one judgment is there where title, possession, everything declared in my favor. Now, this honorable court, after thinking, there is a prima facie has stated. I am not on that point. We will have an argument on that point. Now, taking advantage of that state, if someone is going and destroying all the forests, I have approached DC, OC, but they are saying that matter is pending before the High Court. Now, what is the remedy left with me, man? Now, I have to just keep watch, let him to destroy all the things, waiting for
Probably
this.
both have to go before the civil court and.
That's why, my lord, though both the parties, my lord,
including claiming compensation.
my lord, I may be also restricted, my lord. Both the parties may be restricted from destroying more, my lord.
Let us examine, let him file objection.
But in the meantime, let him to continue with all destruction process, my lord.
Yes, we'll send this matter to the mediation center.
Yes, sir.
Okay. Mr.
B. Sibo, on behalf of T Time.
V. Sibu, appearing on behalf of Mr. T. Tan, Milani Council for the appellant. Also have Mr.
T. Minky, my lord.
T.
T. Minky.
Your name is not there?
No.
Appearing on behalf of
Ojing Padama.
Mr. Ajing Pada, last counsel for the respondents. So the respondent is Ajing Pada is for respondent number?
For sole respondent.
Sole respondent?
Yes, Your Honor.
MHCT, how it is sole respondent? Make appeal, okay. You are for the insurance,
Yes. I am proclaiming, Your Honor.
claimant.
Yes.
There is an element of settlement of the matter through mediation. So, on the consent of both the land council for the parties, let this matter be referred to the mediation center, the High Court mediation center. The registry shall take steps to refer the matter before the refer the matter to the before the mediator for settlement or mediation to the special mediation drive. This mediation for the nation. Special mediation drive, mediation for the nation, that should be within inverted comma. Okay. Okay, that will be enough. Okay. This is 13 and 14, huh? Yes. 13 and 14. Okay. Oh.
Lordship, I am for respondent number 1.
You are for?
I am respondent number 2.
Okay. No one for appellant. Who is for the appellant? Dr. Bhagwan, please, Sharing. Sharing was present. We'll send it if it doesn't settle there. It will come back. Okay. Because the registry will issue notice.
Lordship, I have been instructed by the conducting council to seek a day or two for taking instruction from the client.
Not required. Not required. There is an element because MSA and make appeal. Almost all the matters are used to be forwarded or sent before the mediation center. So try once. If it doesn't settle, no problem. It will come back automatically. Okay. Similar order. Hard, Mr.
BCB on behalf respondent number 2.
On behalf of Jitalo Ipine.
Okay.
Respondent number 1.
For respondent number, you are for respondent number 2.
2.
Okay. And no one appear on behalf of the appellant and then responded. Okay. There is element. Okay. That will be same. And although the appellant is, you inform the appellant also. Okay. Although the appellant in absence, since there is an element of settlement through mediation, comma, is let this matter. Matter is forward. Let this matter be forwarded, referred to the mediator for settlement through mediation. The registry takes all necessary steps to refer the matter to the mediator for settlement through mediation in the present mediation in the special mediation drive mediation for the nation. Okay. Settled. Okay.
Lordship, I'm the sole respondent and this matter has been listed for mediation. However, I prefer to be heard before this honor court. Since this matter has already been fixed for admission hearing on the previous occasion, Lordship.
And in the lower court as well, it has already gone through 1.5 years, and in this court as well, it has been pending for last 1 year. So now that it has been already fixed for admission hearing. This is for the interest imposed by the learned trial court against this present
This NIA
petitioner.
NIA case
Yes,
can be referred to the mediator.
Lordship, I have no interest in mediation since it is already.
Okay. You are for the
I'm for the respondent, Lordship.
respondent.
Yes, Lordship.
You are for the petitioner.
Yes, Your Lordship.
What about you? You are Mr.
P. Wangpan, Your Lordship.
Learned Counsel. Your name is not there. Your name is not there. No wakalatnama. Have you filed wakalatnama? Have you signed wakalatnama?
No, Your Lordship.
Okay, you are appearing on behalf of?
J. Jongloju, Lordship.
Okay. Mr.
P. Wangpan.
P?
I am
Your
P.
name-
Wangpan, Your Lordship. P. Wangpan. On behalf of J.
Appearing on
Jongloju.
behalf of Mr. J. Jongloju, Learned Counsel for the petitioner. Also had Mr.
HRP.
H. Ape, Learned Counsel, appearing on behalf of respondent. You are for sole respondent?
Yes, Lordship.
One respondent. Mr. Ape, Learned Counsel for the respondent. This was listed in admission column earlier.
Yes, TCR was called, and
Have we received? It's
it
there.
was received, yes.
Okay. Hmm.
So it may be fixed for.
Okay.
Meantime, Lordship,
Record. Has been received. Start. Since the parties have been represented and Clerical record has also been received, let the matter be listed for admission hearing after 3 weeks.
4 weeks, Your Lordship.
Hmm?
The 4 weeks.
Why? 4
Leading
weeks.
counsel is our station, Your Lordship.
Okay, after 4 weeks.
okay, no, sir.
Your Lordship, I would like to submit that there is interim order, Your
There is
Lordship, that may
interim.
be continued.
By which order? Hmm? What interim? By which order interim order was passed?
Your Lordship, I may be mistaken, Your Lordship, pardon me for that. My senior instructed that there is some interim order.
There is no interim. Yes.
There was one missed case, Lordship. I have just known they have filed against the recovery petition which I have filed before the learned judicial magistrate first class. So I wasn't given the copy, so I am not aware of the which number.
Okay. This is along with IA. Okay. And the interim order passed in IA 84. The IA is not listed again here. IA disposed of. There is interim here. check amount has been deposited. And already been paid and. So the bill the final consideration. You have challenged the. What is the challenge in this case? Sorry. See, it was not continued. What is this IA video here? Operational. The prayer in the IA is for the order against the order 25/9/2024. But then here in the criminal revision petition, it is against the order dated 15/7. It's different.
15/7 is the order passed by the learned judicial magistrate first class in the main case.
Main case, that has been stayed.
That wasn't stayed, Lordship.
Says, considering that the check amount has been already paid
Yes,
and what remains to be paid is. an
it's the
amount of
interest,
5 lakhs.
interest amount of is 5 lakhs. And later on, they have filed, they went for appeal against this 5 lakhs before the session court, which against was rejected since they had not come in clean hands. Thereafter, I have filed for.
Is of the view that till the final consideration of the connected criminal revision, that is this. The criminal revision petition, the judgment dated 15/7/2024. Yes, it passed in CR case number 29. Yes. 2023 shall not be executed. This is a stay. See, little difficult.
Thereafter, I had filed one recovery petition, IA criminal number 4 of 2024. So I was under the impression that they might have got stayed against this.
See, difficult. Yeah, the present filed to stay the operation of taken 25/9. What is 25/9/2024? What is this order about? 25/9.
25/9.
Judicial magistrate, order by judicial magistrate first class.
– 25/9/2024 is probably when the recovery petition was admitted.
See, there is difficulties. You just have to, because there is no
Yes,
stay in
Lordship.
provision petition.
Lordship, 25-9 is recovery petition IA criminal number 4 of 2024. On this date, a notice was issued. 25-9.
See, the operation of the order is 25-9.
Yes.
No, this order 25-9 order is
Is the your notice was issued on 25-9?
notice.
Yes, for recovery petition.
There are
Not 15-7, judgment dated 15-7, year 5 lakhs interest was imposed. Now, to receive this 5 lakhs,
15-7 has been operation of the judgment in 15-7 on 15-7.
yes. Now, based on this 15-7,
That has been stayed.
since based on this 15-7, I have filed for recovery petition on 25-9.
The prayer is only to stay the operation of the order dated probably 25-9. Twenty-five-9 is the order where the court observed that the accused persons are liable to undergo 6 months of imprisonment. However, it granted last opportunity to repay the entire amount and issue notice.
This
Issue notice to the- this is only. Yes, yeah, same. Notice was issued. So stay the operation of the, and then this application is to stay the operation of this 25. And okay, so you have already paid.
yes, I have received 65 lakhs. That is the total check amount which was
You have
lost.
already paid. You have received how much is yet to receive?
5 lakhs interest imposed by the learned judicial magistrate first class on judgment dated 15-7.
5 lakhs you are yet to receive.
Yes, Lordship.
But then it appears that the land council for the petitioner has said that already paid and remain already paid. And what remains? 5 lakhs.
Yes.
That in the final consideration. So that has been stayed. Operation of the judgment. 15-7. But some difficulty. Some confusion, some confusion.
In your petition, Your Lordship, page number 26.
Which petition?
Page number 26.
Criminal revision.
Yes. Lordship.
Just a minute.
Page 26, Lordship.
Yes.
In the light of aforesaid discussion, I am of the considered opinion that the accused person are guilty of offense under Section 138 NI Act. The accused person shall pay 65 lakhs to the complainant. Any payments earlier made shall be adjusted from the said amount. Further, the accused shall pay,
5 lakhs.
shall also pay 5 lakhs as interest.
65 lakhs.
Yes, I have received the 65 lakhs, but this 5 lakhs I have not received yet. 5 lakhs as interest to the complainant.
Within 15 days.
Within 15 days, yes.
But then that has been, by this order, that has been stayed, it appears.
So since they did not pay it,
See, considering the check amount, sorry, already been paid 65, okay?
yes,
What remains to be paid is an amount of rupees 5 lakhs.
yes,
This court is of the view that till the final consideration of the connected criminal division petition, the impugned judgment dated, this judgment dated 15/7/2024, pass NCR case number so and so, not be executed.
yes.
So that there is a stay, but
Yes.
it has not been linked with this. And then it has not been reflected here. 15/7. This has been stayed. There is a stay.
Yes, there's a stay.
And then this was passed on 22/10. So this has not been reflected here in the main civil division. That is why there was a confusion. Okay, so listed for admission hearing now after 3 weeks.
Yes.
In the meantime.
Your Lordship, it may be fixed for 4 weeks if possible, Your Lordship.
4 weeks, okay. The interim order passed. Okay, the interim order, in view of the interim order passed in IA Criminal 84 AP 2024. Passed by this court on 22/10/2024 in IA Criminal 84 AP 2024. Why this order was possible? We can't change the operations of the bank. The judgment. So the interim judgment dated 15/7/2024, passed in CR case number 29/2023, shall not be executed. This says that if the final consideration of the connected criminal division in further order. This is matter after 4 weeks. As great for comma, this is matter after.
Lordship, the only request is that I have requested previous counsel also. He has come for the first time, although my brother. Please serve me a proper copy of the
You serve the
criminal
copy.
person,
Yes,
because
yes.
all these are
Mr.
printed.
Mr. So and so, Learned Counsel for the petitioner shall furnish a complete set of a copy of the complete set of criminal revision petition to the Learned Counsel appearing on behalf of the respondent within 3 days from today. Okay. Yes. But then you see what I was proposing was to, because 4 weeks is in the mediation, if it is sent, it will come back automatically within 4 weeks. Any interest was granted in these 5 lakhs?
No,
Only to repay.
no, this 5 lakhs is the interest.
Only, oh, sorry, this is interest.
This
There
is
no
it.
interest upon the interest.
No.
Okay.
However, I have paid for it, for the interest upon interest, because again, it has been pending for last 1 year.
Okay, if you are not ready, it will not change. Much. Okay.
If I am appearing on behalf of Titaba. For the
So
petitioner.
can it be referred to the mediation?
Okay, Lordship.
Okay. This is against the state. Yes, Lordship. This is on merit.
No, settlement, Lordship. Settlement, Lordship.
Settlement.
It's a joint petition.
Yes, Your
Lordship.
Lordship.
Joint petition cannot be sent there then. There is no dispute between the parties.
Yes, Your Lordship. They have already settled the matter.
And otherwise also, Lordship, offense is 379.
Offense is?
379/511, Lordship. Attempt,
Okay,
Lordship.
attempt.
Lordship.
Attempt to?
Still. Attempt to still the
No need
PA.
to send, no need to send them.
Yes, Lordship.
We can dispose of.
Yes, Lordship. Definitely. Attempt to steal the BSNL, BSNL cable, Lordship.
Okay, hard miss.
And Hondik. And Hondik.
On the Land Council for the petition. Also heard Mr. Lorry, Land people. For the state. This application has jointly been filed by the petitioners under section 482 of the Code of Criminal Procedure 1973 for quashing and setting aside the proceeding in GR number 239/2022 arising out of SLG means Sagali or what?
Yes, Lordship.
Sagali PS case number 04/2022 under section 379
PS.
511 511/34 IPC. The GR case, after GR case pending before the Court of Chief Judicial Magistrate, Capital Complex UPR, then arising out of, okay? The Sagali PS case number so and so. The petitioner number one, Sri Nabam Sunil is the informant.
Sir, he's the accused person. He's the accused person.
Why you have written informant?
Respondent number 2 is the informant complainant, Your Lordship.
Yes, it's wrongly mentioned in the lordship, post title lordship.
In a ghost title, Nabam Sunil is informant.
Or
Now
yes,
Sunil is the accused person. Alleged.
Accused?
Yes,
The
Your Lordship.
Just let us see where is the FIR then. Nabam Sunil has been recorded as informant.
In page number 28, accused number 1.
Or Teli Nega is the informant.
26.
See, these things are small, but then you see, you have to take care.
Lordship, FIR is at 26, lordship, 26, type copy is at 27, lordship.
Yes. The petitioner number 2, Teli Nega, is the informant. And the petitioner number 1, Nabam Sunil, and
134, lordship.
the petitioner number 3, Sri Tabru Peter. Sorry, the petitioner number 1, Nabam Sunil. The petitioner number 3, Tagru Peter, and petitioner number 4, Sri Mohammad Manjur Hussain, are the accused in the aforementioned year number 239/2022, arising out of Sagali PS case number
4 of 22.
4, 2022. So, the case of the petitioner is that the petitioner number 2 filed a written FIR before the officer in charge, police station Sagali, inter alia alleging therein that on 23/3/2022 at around 8 a.m.
Accused dismantling Pidarar cable climbing, dismantling lordship, Pidarar cable climbing on the tower, lordship. Dismantling
the accused persons, the accused applicant number 1, 3, and 4
Dismantling.
they were sent for dismantling. These accused persons.
Not sent for lordship. They are trying to steal the
Okay. Where
By dismantling.
court red-handed while trying to while trying to steal, while trying to dismantle, where while trying to dismantle feeder cables by climbing on the tower with a view to steal the same. Based on the above FIR, the aforesaid Sagali PS case was registered. Sagali PS case number 04/2022 was registered under section 379, 511, 34 IPC. So after completion of investigation, the charge sheet was filed against the accused petitioner number 1, 3, and 4 for offense under section 379, 511, and 34 IPC. What happened? What is the status of the trial? Hmm?
Lordship, it is in the stage of appearance.
Appearance,
Yes, your lordship.
not yet, no charge was framed. As per their statement, there,
Yes.
it is
Charge
for
is not, charge
appearance.
has not been,
Hmm?
charges have not been framed yet.
Not yet framed.
Yes, your lordship.
The, okay, the code is there. Whether case has been taken into cognizance. Okay. Coming to charge it under section so and so, no? And the case was, accordingly, the cognizance of offense under section 379, 511, and 34 IPC was taken against the accused persons. The case is now pending trial before the Chief Judicial Magistrate, UPM. It is the case of the petitioner that during the pendency of the trial, the parties have amicably settled the matter by executing a deed of mutual settlement amongst the parties on 22 to 2024. The in the deed of settlement, the informant, petitioner number 1, clarified that due to some misunderstanding, he had lodged an FIR against accused persons. And he immediately after lodging FIR had expressed that he wanted to withdraw the said FIR lodged against the accused persons. And since the matter has amicably been settled, he has no further grievance against any of the three accused persons, and therefore expressed that he wanted to withdraw. And further expressed that he do not want to pursue with the case any further stuff. The parties have also resolved to approach the trial court for compounding of the trial court for closing the case. However, there is the offense. Which offense is not compoundable? I see.
511. 511.
Is not compoundable. This is 79 is compoundable, of course. Okay. No. Okay. 511. The offense under section 511 is non-compoundable, and the magistrate and non-compoundable and is beyond the power of the chief judicial magistrate. The petitioners have filed this application before this court, seeking compounding of the case. Stop that. The Lanet PP, Mr. Loy fairly submitted that the allegation against the accused is only that they attempted to commit theft. However, the matter has been amicably resolved between the parties, clarifying the misunderstanding by executing the deed of mutual settlement on 22/2/2024. Rama? 2024. And the informant has no further grievances and does not want to pursue with the case any further. Therefore, under the circumstances, he has no objection if the prayer of the petitioners are allowed. Stop. Are both the land counsel for the parties. I have also considered the records. It appears that due to some misunderstanding, the informant lodged a written FIR against 3 accused persons, alleging for attempting to commit theft. However, the matter has amicably been resolved between the parties by executing deed of settlement dated 22/2/2024, whereby the informant expressed that, whereby the informant clarified that he had lodged the aforesaid FIR against the accused persons due to some serious misunderstanding, and since the matter has amicably been resolved, he has no further grievances against the accused persons, and therefore he do not want to pursue with the case. Stop. Under the circumstances, it appears that the further proceeding of the case before the trial court would only result in futile exercise, as there is no any scope of there is no chance of conviction in the present case. Instead, stop. Have I said under the circumstances? Okay. And it would only amount to abuse of the processor staff. In such cases, the Honorable Supreme Court in Katina of cases has decided that the High Court and the Supreme Court, in exercise of the inherent power under section 498 within bracket corresponding to the section 482, sorry, 482 of Criminal Procedure Code can compound a non-compoundable offense if the accused is not likely to be if the accused is not likely to be if the trial is not likely to be resulted into conviction. In view of the above, and as agreed upon by the parties, this court is of the opinion that no fruitful result is expected, even if the proceeding is allowed, even if the trial is allowed to be proceeded against the accused in the instant case of start. Accordingly, the prayer of the petitioners are allowed. Start. As a result, the proceeding of the case in GR, proceeding of the GR number 239/2022 under 22 before the Court of Judicial Magistrate, Capital Complex UPR, arising out of the Sagali PS case number 04/2022 under section 379, 511, 34 IPC is hereby set aside and quashed. With the above, this petition is allowed and disposal. Some correction would be required, huh, here in this case. 18N.
Lordship, in 18, I am for the respondent. In 19, I am for the petitioner.
In 18, you are for?
In 18, I am for the respondent.
For the respondent. In
Yes.
19, you are for the
Petitioner.
petitioner.
Yes.
So what is this matter about?
This matter is for quashing. 18 is for quashing of a matter which is currently pending before CJM UPR.
It's a joint petition or the
No, Your Honor.
On
Not
merit.
a- No.
Hmm?
It's not a joint petition, Your Honor.
Not joint, but that is
No.
why. Challenge on merit.
Yes.
Who are the respondent? Informant. What is the offense involved? What is the offense?
Lordship, actually, this matter is regarding maintenance.
Maintenance.
Yes, Lordship. The
I think
petition-
this can be. What is? This matter can be. referred
Lordship,
to
I
the-
have the same prayer here. The conducting counsel has asked for a day or two, just for seeking instruction from the client.
Okay,
1 or 2 days only.
okay, Mr.
Ipayan.
E. Payne, Direct Counsel for the respondent in criminal petition number 45, 2025, and petitioner in criminal petition number 212, 2023. Want to obtain instruction before referring the matter to the mediation and prays for some time. The prayer is allowed, and none appears on behalf of the other side. The prayer is allowed. List this matter after 2 weeks.
And Lordship, in item number 19, there is one interim. It may continue.
Stop, huh? The interim order passed in criminal petition number 212, 2023 shall remain, continue till the next date of listing. Okay,
Be obliged.
yes. Yes,
Your Lordship, I am referring on behalf of our Soigi, Your Lordship.
it's okay.
Earlier
For
today-
the petitioner.
Yes,
For
Lordship.
appellant.
Yes, Lordship.
Who is for the respondent?
Your Lordship, today morning I asked
PP.
for. I couldn't get in contact with him. Your
Whether
Lordship.
is there any private respondent here in this case? Yes. What is this? This is criminal division.
No, Your Lordship.
20 item?
22.
22?
20.
Sorry. It's appeal. I thought this is 24. 22 not yet over. Okay. So, you are for the appellant.
Yes, Your Lordship. I'm appearing on behalf of our Soigi, Your Lordship.
Okay. Mr.
M. Tasso.
Direct Counsel for the sorry, Land Council appear on behalf of Mr. R. Sarkar, Land Council for the applicant. None appears on behalf of the respondent. In absence of the Land Council for the respondent, the matter stand adjourned. List this matter after 3 weeks. Okay.
Obliged.
Your Lordship, I am on behalf of Titorum. Your Lordship, the conducting council is out of station, so may I adjourn the matters for today and fix
Okay.
it after 2 weeks.
Okay, Mr. You are
Titorum.
Mr.
A Miura.
A.
Miura.
Your name is there.
No.
Okay, Mr. A. Nyora.
On behalf of
Council.
Titorum.
Some states, the conducting council, Mr. T. Torum, is out of station, therefore pray for adjournment of the matter for 3 weeks, to which the line PP has no objection. Accordingly, the prayer is allowed. List is matter after 3 weeks. Okay. Anything else? Finish. Okay.